And during this interview also, did you and or Officer Jansma use different themes?
Yes.
And describe to the jury what a theme would be as an example.
Well, like this one, we try to minimize the crime. We make the victim more to blame. Just bad people don't like to, when they do something wrong, they don't like to admit it, so we make it a little easier.
Your Honor, I'm going to object to the approach.
Why don't we do this? We're right next to the lunch hour. I think that is safe. 15:30 start time. We'll resume at 1 o'clock. Why don't you take a jury and take a matter? Please.
We got a serious problem here. The defendant had moved in London, and I think it was very clear that the issue here of good character or bad character is not to be admitted by the state. And we've got a direct violation of that, an intentional violation of that by the state. The question to Chief Thompson was about his techniques in interview. Mr. Smith asked him what were some of the techniques that he used. He talked about minimizing, trying to make the victim more to blame. Mr. Thompson, Chief Thompson, then stated that bad people, I guess I'd go back to the record, I believe bad people don't like to admit when they've done something wrong. You know, that's just unconscionable character. I mean, he has directly called the defendant a bad person. He's implied that the defendant, through his denials to the police, is a bad person, and that he has been essentially tricked into admitting that he is, in fact, a bad person. I don't see any cure for that, Your Honor. I guess I would move for a mistrial at this point.
Your Honor, the state would resist the defendant's motion for a mistrial. The state's recollection of what the witness testified to was, in general, he used the term he may have used, bad guys in general don't like to admit. He did not say specifically the defendant's bad guys. Obviously, a better word choice would have been suspects don't like to admit. But again, if this can be cured by the court admonishing the jury to have the last portion of that stricken from the record, the state doesn't believe at this point it rises to the level of a mistrial, because this witness did not say the defendant was a bad person. He was talking in general when they used techniques for interviewing suspects. So the state would resist the defendant's motion for mistrial.
I don't think there's any way that you cannot interpret that as Chief Thompson calling him a bad person. Clearly, the way the question and answers were flowing described the defendant as a bad person, and that's why he had to use these techniques to get him to make admissions. I don't think the limiting instruction does anything once that bell has been rung. That's why we had the whole motion in mind.
I'm going to look at what the transcript says at that point, and I'll get you. Why don't you, gentlemen, be back here maybe about 20 to 1.
All right.
Ken Hill, is there anything further you'd like to say regarding the matter?
I would, Your Honor. I had initially made my objection in the grounds of the mistrial on the comment about bad people. When I look at this answer from Chief Thompson, it's really much more complex and I think much more harmful. He starts out, when he asks about the theme, he says, oh, like in this one. So he's referring specifically to this case. This is a direct reference to what was done in this case. He says, minimize the crime. I think that's a comment that on both the credibility of Mr. Green's statements and also a conclusion of law and fact. It says we make the victim more to blame. I think, again, victim, just like I had objected in the motion in limine on murder and murder weapon, it's a conclusory statement. It implies that Mr. Coster was innocent and Mr. Green was not. And then talking about bad people doing something wrong, that is just over the top, especially given the considerations and the lengths to which we had to deal with this in the motion in limine, the way that I've altered my case to avoid character coming into it, calling off our witnesses, not getting into this area. I don't see how I'm supposed to be able to respond to this. I don't see how you can unring this from the jury's mind. It is so central to the case because the defendant is going to be testifying. And there's an 8th Circuit case, U.S. v. Espinoza, 585 F. 3rd 418.
I'm sorry, what was that again?
585 F. 3rd 418. I don't have a year on it, Your Honor, but it is an 8th Circuit case. And it talks about whether the improper testimony was critical to the credibility issue. And I think that clearly that's all this is designed to do. It's supposed to say, hey, I'm a good guy. I wear the white hat. I've got the badge on the stand today. I'm on the good side of things. And that guy over there, in this case, he's the bad guy. He's bad people. And he committed a crime, and Mr. Coster's the victim. I just think it was just such a poor answer. I don't think that this case can recover from it. I think the prejudice is too great, given the central issue of credibility in this case and the defendant having to testify.
Yes, Your Honor. Your Honor, the state would strongly disagree. Chief Thompson did not make any statement in his answer on the defendant's credibility. The defense wants to bootstrap his choice of words to a theme in general. That was the question. Describe to the jury what a theme would be as an example. There was no question to him saying anything about the defendant's character. Now they want to bootstrap a general theme answer that he gave. And he did say victim in general. There was no motion in limine by the defense on victim. The only word he used that they're trying to assassinate him on is, he said bad people do something wrong. They don't like to admit it, so we make it a little easier. And that is true in general. He should have used the word individual, maybe suspect. But there isn't anything in this answer that goes to the defendant's credibility. It doesn't go to the defendant's character. This can be cured in a couple ways. One, the court can ask the jury to disregard the last statement. Two, there can be clarification that the Chief Thompson will say, I was saying in general. I wasn't referring to anybody's character. I'm just talking in general. Or three, we just move on and not draw attention to it because it was in general. There isn't anything in this answer that says that the defendant is a bad person. And that's what the defense wants the court to make a motion for, or grant a motion for a mistrial. It would be a closer call if Chief Thompson said, I believe the defendant is a bad person. Clearly, that puts his character at issue, and then the court would have to see, is there any way we can cure that? That's not what we have here. The state believes that this can be cured, and a motion for mistrial is not the remedy that should be granted. Thank you.
Can I just respond briefly here? Sure. I mean, Not that it wasn't directed at this defendant. The first few words there, like in this one, he is referring to this case, this defendant, this process.
Mr. Hammer, let's assume for discussion purposes that we approach this matter from the standpoint of trying to clarify what this answer was. It would strike me, maybe I'm wrong, you know better than I do, but it would strike me that this matter is going to come up probably again during testimony and more than likely during the as to this matter of theme or whatever as to, am I wrong on that?
You're not, Your Honor, and it will come up with the Assistant Chief Jansman, because he was the main interviewer. He's been instructed, obviously, that it's not the way the answer was bad. But the officer, the state believes that this question asked is how they explain when they use themes. Is it an appropriate technique that they use for interviewing? We think it's a relevant question. The answer should not have been couched in the terms bad people. The state understands that it would be couched when they interview individuals. They use different themes and techniques. And their techniques are they minimize conduct. If the person that was involved, whatever you want to use the word victim, but the person, they blame the other person, and they use these techniques, but they're talking in general, and we can make an emphasis on that with Assistant Chief Jansma. We could come back and make an emphasis on that with Chief Thompson. And it seems to me that it's appropriate for the state in closing to address that these are techniques that are used. And the reason it's important is because when you watch the interview, the defendant doesn't admit that he did this right away. It's only after these techniques were used that he finally latches on, because they give him suggestions. They blame Mark's mental health. They blame, they say there were accidents, mistakes happen. And it's then when he latches on to this. So it is very important for this case, for this technique and themes to be explained. And I understand the court's concern is the wording has to be better by the officer. This was not the wording that should have been used. The state agrees with that.
My concern is that because that was the wording used now, that every time this matter is then brought up again, this is going to be in the minds of the jury.
Well, Your Honor, I mean, we're assuming things, but I think that's an assumption that it may not be. And they just heard it. There was an objection. They left. It seems to me if that's the concern of the court, then the first question we should be able to do is clarify to Chief Thompson, before we left court, when you talk about themes, were you talking, he says in general, just in general, interview individuals. Because they interview individuals that don't have, they're just witnesses in crimes too. So they interview individuals. He could clarify just individuals. We're not talking, not even reference bad people.
How do you deal with, this is the technique we use with bad people, and this is minimizing the victim as to, I guess my concern is when you characterize the person as a victim and say we minimize their, suggest that they have done something wrong. And that's what this answer suggest.
And we
And
did,
how do you deal with those two issues? I understand what you're saying. Okay, this is the theme I was talking about, generalities. How do you deal with the other two matters?
the other two matters would be this is, the officer could testify that what we do is we try to minimize the person we interview and their involvement. And we give them different techniques, we throw out different possibilities, and leave it at that, and then they'll get to watch the video when they blame the victim in this case. And then that way they're not talking about the word victim, they're not talking about bad person.
But how do you, I mean, that has been said at this point.
Correct. But
So how do you clarify that I really didn't mean victim and here, and I didn't really mean bad person? We use this technique whether or not.
Sure. And one way the state would suggest, Your Honor, is have the witness say, I'm just talking in general. Okay, I'm not talking about any specific case. I'm just talking in general what we do. And that's in general what we do. I'm not talking about this case specifically, in general what we do. And then follow it up with were different techniques used through your interviewing, training, and seminars that you went to? Yes. And were they used in this case? Yes. And then we move on. Just so we make the point of emphasis, we're just talking, that last statement, he was just talking in general, he's not talking in this case.
But how do you back off on the fact that it has been said that this person, that we use this with bad people and we use it to minimize I guess accentuate the victim's conduct, because that's what's said.
Right, and I guess, Your Honor, the only way, there may be other ways that I'm not thinking about, but I think the point of emphasis is when we take a stand is to explain, if the court wants to, if the court doesn't want to admonish the last statement to be stricken, let's say the court does that, the last statement is stricken, then the state would say, just in general, when you interview people, do you use different techniques? Yes. And how did you learn these techniques? You went to training, grade school, and these techniques were taught. And then leave it at that. Then. We don't even want to get into the specifics. The interview will speak for itself. We can focus on the straight.
Let's assume it's stricken. Okay, let's strike that approach for a moment. All right, I'm just trying to find out where we were. If we said it's stricken, then what else do we tell the jury about what was said?
If the court and the defense wants to, the court could say that that last statement that was made was not a reference to this case. To clarify, that was just in general.
Your Honor, if I may.
Well, I'm going to give you a chance. You're going to get your opportunity, Mr. Kendall. I'm just asking questions right at the moment.
And so, if the court strikes it, and then admonishes the jury, and then the state could, if allowed, just say, did you go to interviewing schools? Did you learn techniques? And just talk about interviewing schools, general aspects, not get into victim, and just say that we learned different techniques of interviewing people, individuals, not get into blaming the victim, not get into that type of conduct.
Kendall.
The problem with this suggestion, Your Honor, the court going back and saying, oh, that was just a general statement, is that it's not. You know, you're asking the jury to, they heard in this case, I did this. And you're asking them to go back and say, you know what? That's not what he actually said. So disregard it. And by the way, that's not what was actually said. I mean, that's ridiculous and ludicrous to think that that's going to have any sort of prophylactic effect on this defendant's right to a fair trial, Your Honor. This is an affirmative statement of what this officer did in this case that portrayed the defendant as a bad person It directly violated the motion in limine. It's an issue that's central to this case. There is no way to undo this damage, Your Honor. I do not enjoy asking for this, Your Honor. I do not relish at all in having to start over when everybody has worked so hard to get to this point. But what possible remedy could there be? They portray this when they go to talk to Tom Falke, the testimony. They don't talk about any of these having to use these interview techniques, and Tom Falke's not a bad person, but then when it comes time to this case, in this interview, it's different because we used a theme in this one, because now we got bad people on the other side of it. And he's sitting there with his badge on and wearing the white hat, and it is just so unfair to this defendant who's going to have to come down the road later and testify, and you know that he's going to get up there in closing argument and talk about theming, and that it was that they got him to admit it through this great technique. When then the court's concern there is real, Your Honor. This is not an issue that's going away. They should have done a better job preparing this witness, given the court's direction in the motion in limine, the specific issues, that this should not be something we have to deal with.
Just briefly, Your Honor. Obviously, Mr. Kendall is making a big issue out of the whole like in this one, but it's interesting that none of us caught that until we saw the transcript. So we're again assuming things that what the jurors heard or did not hear, which could be cured by an admonishment and clarifying. Also, if it makes it any difference on the Tom Falke, we never went into the interviewing techniques, but clearly, if they want, we can ask the same techniques we're using Tom Falke's case. So, I mean, it's not that they're trying to make one worse than the other. They're focusing it on the interview where the defendant made admissions.
Well, I mean, a few of my observations. One is, I think the question was fine. I don't think there's anything wrong with exploring the interviewing techniques. I think the answer was not responsive to, really responsive to the question. Also went up into some other matters that are not appropriate. For those reasons, I think the objection was certainly timely, and the motion was certainly timely. What bothers me most about this is that it has occurred very early in the case. And it is something that, from my observations of the way this case will be tried, will be brought back from time to time during this course of this case, and I am sure will be argued at in final argument, not the officer's characterizations, but how the themes work and everything. And this is now, if I understand psychology a little bit, this is the first thing these jurors have heard on this subject, and therefore is most likely to be remembered. I think a fair reading of this matter is that you use this technique with bad persons. Seriously doubt that's even true. Probably many cases. Secondly, it implies that the officers have evidence different than what they may have said during the interview. And again, the jury hasn't heard anything else yet. They've heard this. And and this is, for the most part, what this case is all about, is who did what and how it came about. And that's going to be the main subject of this entire trial. And I can count on one hand, 20 years, the number of cases I've held on the mistrial. But I do not believe in this case that with having it occurred in the beginning of this trial, before the jury has heard any real evidence about these matters, I don't think you can take the approach of clarification, because I don't see how you can really clarify the terms that he talked about with using it for bad people and for maybe blaming the victim. It implies that they have other information to me when you talk about blaming the victim other than what's there, and they haven't, and maybe there is other information, but they haven't heard it at this point. So I don't think clarification is really, I can understand clarifying the theme and all that, but I have difficulty clarifying the part about bad person and victim, blaming victim. So I don't think clarification is a reasonable approach. The idea of just striking the matter maybe has a little more, makes a little more sense. But to then just tell them that he was just speaking in generalities or something, again, I don't think really solves the issue of the thing that has been set in their mind at this point in time in the trial. And accordingly, the court has granted this trial.
What is the contact court administration for a new trial?
I'll tell them,
Okay. Thank you.
we're going to bring this way back.
All rise.
Gentlemen, a matter has come up that has required me to declare a mistrial in this case. Accordingly, your jury service is included in this matter, and I'll be ordering that a new trial be set. But your services is completed at this time. Thank you very much for your services. As I said, I declare a mistrial in this matter, and accordingly, this trial is over.
All right.
I should say one other thing before you leave. I don't know whether anyone would be contacting you about talking to you from the media or anything of that nature, but you have the absolute right to either talk to them or not talk to them. That's up to you folks.
Okay, we're going to split. No, don't have to. Yeah.
Conditions of release remain the same as they have been. Anything further that needs to be addressed, Mr. Cameron?
I don't think so, Your Honor.
Yes, Your Honor. We did offer some exhibits there. Since it's mistrial, can we have those back? We can hold them back.
Sure.
Okay.
Just talk to my court reporter.
Okay. Thank you.